Good morning.
Good morning.
Good morning.
Welcome. How are you all doing today? Today we're going to talk about chapter 5. Can everybody hear me clearly?
Yes, Professor.
Okay. I'm going to start talking about chapter 5. Then I'm going to pause for a little bit in the middle. And I'm going to play a video on legal liability of auditor, which I want you to watch. And then I'll come back and I'll conclude my discussion of chapter 5. So let me go to my and let me go to share screen. So let me start videoing. Share my screen. Okay, here we are. So chapter 5, we're going to talk about legal liability. And when we talk about legal liability, we're talking about lawsuits. Lawsuits involving the auditor. Who may want to sue the auditor? Why would they want to sue the auditors? And when and if would the auditor be liable? Now, what are some of the things we're going to cover? We're going to understand the litigious environment which CPA practicing, and in the United States is a highly litigious environment. There's probably more lawsuits in the United States than any part of the world. So it is important that we understand this litigious environment. Let me just close my door because my dog is barking. Excuse me a minute. Okay. We'll explain the failure of financial statement users to differentiate among business failure and audit failure. Business failure is when businesses are unable to pay their obligation as it becomes due. And it could be caused by a number of things, including management making a series of poor decisions. Audit failure, on the other hand, is when the auditor failed to follow generally accepted auditing standards. When one or more of those standards are breached, there is an audit failure. There's a misconception out there in the business world between business failure and audit failure. Whenever they see that there's a business failure, they automatically assume that there is an audit failure. That may or may not be the case. 3, we're going to talk about the primary legal concept and terms concerning accountants, a basis for studying legal liabilities of auditors. We're going to talk about fraud, ordinary negligence, gross negligence. What do they mean? Contributory negligence. What do they mean? 4, we're going to describe accountant's liability to client and related parties. What are their liabilities to their clients or third-party users of the financial statement? 5, we'll talk about accountant's liability to third parties under common law and what defenses they have. 6, we'll describe accountant's civil liability under the federal security laws and related defenses. We talk about the Securities Act of 1933. What are the accountant's liability under the Security Act of 1933? What are their responsibilities under the Securities Act of 1933? We're going to talk about the Securities and Exchange Act of 1934, how those acts affect accountant liabilities. We're going to talk about the Foreign Corruption Practice Act of 1977, what it is and how it affects accountant liability. We're going to specify what constitutes criminal liability for accountant. When can the accountant be held criminal liability? Criminal liability means that you're going to the slammer, you're going to jail. Whenever there's fraud, the accountant can be held criminally liability if they are involved in that fraud. And 8, we'll describe how the profession and individual CPA can reduce the threat of litigation. So let's dive in. The litigious environment in which CPA practice. The auditor and the client signs a contract. Like any other contract, there are two parties to this contract. The client gonna pay a certain fee to the auditor. The auditor gonna audit the financial statement in accordance with generally accepted auditing standards. If the auditor is negligent in performing his obligation or her obligation, then, and the client suffer a loss, then the client can sue. A lot of times accountants are being sued by their clients. Either they did not complete the engagement on time, they failed to complete the engagement, or they failed to detect an error or irregularities. So we will try to determine under what circumstances may the accountant be liable, and under what circumstances may the accountant not be liable. The number of lawsuits and sizes of award remain high. And this is why accountants have to have malpractice insurance. Like the doctors, the medical profession, where malpractice insurance is very high, we also are facing a high rate of malpractice insurance. What contributed to this changed legal environment? Well, there's a growing awareness of financial statement users. They rely on a financial statement, they suffer a loss, they try to sue the auditor. Why? Because at the end of that process, if you go and buy stocks of a business, let's say XYZ business, and you bought $1 million worth of stock, and the company go bankrupt, your stock become worthless. If the company go bankrupt, you can't go and sue the company. They got nothing to collect from. But the only party that's there that could be liable is the accountant. So you will turn to try to see if you could get some money out of the accountant. So you're going to sue the accountant, and the accountant have to defend themselves. Increased consciousness of the SEC. The Security and Exchange Commission is very conscious of what's going on out there. Going back about 10, 15 years ago, they came up with the Sarbanes-Oxley Act because the public was complaining that the accountants were giving clean opinion on these financial statements, and yet some of the companies were going bankrupt. Also today, businesses are more complex than usual. They're more parent subsidiary, they're more complex transaction. If their business are more complex and the transactions are more complex, the chances of errors occurring are much higher. And then fourth, we live in a very litigious society. If you lose money, you're looking to see who you could recoup your loss from. It may not be their fault, but you're looking to see who you could recoup your loss from. Right now, we do not have a global recession. We almost have one because of the pandemic. But go back about 10, 12 years ago, we had a global recession. So whenever we have tough economic times, business failures are increasing. Right now, we have some economic struggles in different sectors of the business. For example, if you're in the restaurant business, and the government have stepped in to bail out a lot of businesses in these tough economic times, so that we were not going to have so many businesses going out of business. But the economy overall, I think, is doing fairly well, except for certain sectors. There are also some large civil court judgments against CPA firms. And because of this, other individuals who are looking, hey, the CPA firms are paying out, I'm going to sue them too. Maybe I'll get something, right? If they invest in a company and suffer a loss, they're going to want to sue also. And judges and jurors find it difficult to understand these technical accounting matters. They're not business people, most of them, and they do not understand these complex accounting matters. To explain why the failures of financial statement users to differentiate among business failure, audit risk has resulted in lawsuit. Business failure. Businesses are going out of business for various reasons. Could be poor management decisions, could be changing economic condition, like right now we have this pandemic, and some entertainment business, some restaurants are going out of business. Does it mean that there's an audit failure? Not necessarily. An audit failure is when the auditor failed to follow generally accepted auditing standards. So business failure, a business is unable to meet its obligation or investor expectation due to economic or business condition. And you're seeing that right now with certain businesses. Audit failure is when the auditor issue an incorrect opinion from a failure to follow generally accepted auditing standards. Let me just check if I'm taping. Make sure my taping is on. Yeah, I'm taping. Okay, let's get back into it. Audit risk is the risk that the auditors fail to find a material misstatement and issue an unqualified opinion. So business failure, businesses are unable to meet their obligation, could be a number of reasons, management decision, changing economic time, etc., etc. Audit failure, CPA gives the wrong opinion because they failed to follow generally accepted auditing standards, one or more of the standards. Audit risk, the risk that the auditor failed to find a material misstatement and issue an unqualified opinion. Although you did a proper audit, you failed to find a misstatement. Now, I'm going to pause here for a minute on my lecture, and I'm going to play an important video, which is embedded in your course for you guys to look at. So I'm going to still be in my safe screen mode. Let me get back to my course. Hello, everyone, and welcome to Virginia International. Okay, I'll come back later, okay?
Professor, is there supposed to be audio?
Hello, everyone, and welcome to Virginia International University, MBA 605.
Okay, guys, I'm back. So, it was a good talk about legal liability. I think he was lecturing from our text also. So, he gave you a little different flavor. I'm going to just quickly go over some of the things he talked about and dive in a little deeper. The primary legal concept and term concerning accountant liability as a basis for studying legal liabilities for auditors. Legal concept. Some of these concepts we're going to talk about, you probably already discussed in business law. A lot of things that we are talking about in this chapter, if you did business law, you probably talked about some of them already. But a prudent person concept is what a reasonable person will do. Liability for acts of others. If you're in a partnership, you're liable for the acts of your partner. You are jointly and severally liable, either together or separately. That's what it means. Lack of privileged communication. Certain communication that the auditor have with the client are considered privileged communication, and nobody should have preview to that. It should not be shared with anyone. Terms related to negligence and fraud. Ordinary negligence. We talk about ordinary negligence. We talk about lack of reasonable care. Gross negligence. We talk about absent of even slight care. And constructive fraud, the negligence was so gross that it amounted to fraud. And when we talk about fraud itself, fraud is someone have knowledge and intent to deceive. Now, knowledge is not that hard to prove, but intent is a very hard thing to prove. How can I prove what your intent is? You're on the course, I see your name up there, but you have no intent to listen. I can't prove that, right? So intention fraud is a very, very difficult thing to prove because it's very difficult to prove someone's intent. Contract law. We have breach of contract when one party failed to uphold the terms of the contract, and we have third-party beneficiaries. Who are the third-party beneficiaries? The audit contract is between the client and the CPA. The client agreed to pay a fee. The CPA agreed to perform an audit of their financial statement in accordance with generally accepted auditing standards. Those financial statements are shared with banks, creditors, stockholders, etc. These banks, creditors, and stockholders, etc., are the third-party beneficiaries. Common law. Common law are those laws that develop through court decision over the years. Statutory laws. Statutory laws are those laws that are enacted by the government. Tax laws are statutory laws. Security laws are statutory laws. Joint and several liability, you're liable together or individually. And this is what you see in a partnership. Separate and proportionate liability is when you have tenants in common. You're liable for only your share. Accountant's liability to client and related defenses. Generally, the client will sue the accountant if the accountant breached the contract. And the accountant will have their defenses. There are generally 4 defenses available to the accountant. There are also 4 major sources of accountant liabilities. 1, the client can sue the accountant. 2, a third party, such as a bank, a creditor, or a stockholder, can sue the accountant. Third, the accountant can be held civil liability under federal securities laws. We're going to talk about that. The Security Act of 1933, the Securities and Exchange Act of 1934, and the Foreign Corruption Practice Act of 1977. The accountant can also be held criminal liable if they are involved in fraudulent financial reporting. First, let's talk about liability to clients. The most common source of lawsuit against the EPA is from the client. Because the client is in privity of contract with the accountant. By saying that they're in privity of contract, they are a party to the contract with the accountant. The auditor have 4 defenses available to them when they are being sued by the client. The first one is the lack of duty to perform. What do we mean by that? The auditor agreed to do an audit to the client financial statement. Years after the audit was completed, the client is suing the auditor because the auditor failed to file their federal tax return. Well, the auditor agreement was to do the audit, not to do the tax return. So the auditor has no duty to do the tax return. However, as a practicing accountant, you don't want this to happen to you. Whenever a client engages you to do the audit, you offer your other services to them. Hey, can I do your tax return? Can I do the tax return of the owners or the officers? Right? Can I do some financial consulting? That's your opportunity to sell your array of services that you are performing for your clients. Second defense the accountant could raise is non-negligent performance. Non-negligent performance means that the accountant complied with the standards. The accountant complied with generally accepted auditing standards in performing their audit. The third defense they may raise is contributory negligence. One, the client employee stealing. The client sue the accountant. Well, the client contribute to that occurrence because they hire the employee, they train the employee, they supervise the employee on a daily basis. They are primarily responsible for their employees. So their negligence contributed to the act of stealing. Absence of causal connection. The auditor did the audit issue a report on the financial statement, an unqualified opinion. Some stockholder is suing the auditor, but those stockholders never look at the financial statement. They never read the financial statement. Therefore, there is no connection to their loss and the audited financial statement. Accountant liability to third parties under common law and related defenses. Prior to the Ultramar versus Stooge, which is the case in your textbook on page, let's see if I can find the page quickly. Yeah, it's on page 122 at the bottom. Prior to that case, all third parties were being placed in one class as third parties. After the Ultramar versus Stooge, they separate the parties into 2 categories. The first category and the more privileged category is called foreseen users. Foreseen users are known third parties. Third parties the client knows will rely on the financial statement at the time of the audit. The second class of third party are what we call foreseeable users. And foreseeable users are likely users, are potential users. Let me give you an example to explain the difference between the two. Let's say the client called you and they want to have an audit done. And you ask the reason for the audit, and they said the reason for the audit is because they're getting a loan from Citibank. Well, Citibank now becomes a foreseen user because you know that they're going to rely on your financial statement. You did the audit, you issued a financial statement, they go to Citibank for a loan, they get their loan. Later on, they use the same financial statement to go to Chase for another loan. Well, Citibank is a foreseen user because you know that they're going to rely on your financial statement. Chase is not a foreseen user because at the time you did the audit, you didn't know that Chase is going to rely on your financial statement. However, they will come in the category of likely users or potential users. They are being placed in the category of foreseen users. Why are these distinctions matter? Foreseen users are any credit alliances, restatements for thought, or foreseeable users. Why are these matter? If you are a foreseen user, you are considered to be a primary beneficiary. And you're basically given the same rights as the client in the event of a lawsuit. Although you're not a party to the contract, you're given the right as if you're a party to the contract because the accountant knows that you are going to rely on the financial statement at the time the audit is being done. Foreseeable user, on the other hand, are potential users. They were not known at the time of the audit, but they were likely user. Any creditor could have, any stockholder, any credit alliance of the organization could be a possible reliance on the financial statement. So they are considered to be unknown third parties, and they are given different treatment. They are not given the same right to decline. They will only be able to pursue in a lawsuit if the accountant is negligent and they rely upon the financial statement. Now, the auditor defenses against third party. Primary beneficiary is a narrow interpretation of third party. Primary beneficiary are the known third party, and they were designated on the Ultramar versus Deutsch lawsuit. The auditor knows that they intend to rely on the financial statement. The auditor knows that they will rely on the financial statement. Foreseen users are reasonable, limited, and identifiable group of users who have relied on the auditor work. They were not known at the time the audit was done. And they give you an example at the bottom there. So when we talk about foreseeable user, we talk about a broader group. We talk about primary beneficiary or foreseen user, we talk about a narrow group that the auditor knows will rely on the financial statement. In my example, for example, Citibank, right, versus Chase. Number 6, item 6. Describe accountants' civil liability under the federal securities laws and their related defenses. There are 3 securities laws we're going to talk about. We're going to talk about the Securities Act of 1933, which was enacted in 1933. And under the Securities Act of 1933, applied to companies that are going public for the first time. They're required to file certain financial statements with the SEC. They're required to file a registration statement, and including in that registration statement are audited financial statements. Generally, audited financial statement can be from 2 to 5 years. Section 11 of the 1933 Act defined the rights of third parties and the auditor. Generally, if you're suing someone, you have to prove that that someone did something wrong. Generally, if clients are suing the accountant, or anyone is suing the accountant, they have to prove that the accountant did something wrong. Under the 1933 Act, you don't have to do that under Section 11 of the 1933 Act. All the person has to do who wants to sue the accountant, whether it's a client or a third party, all they have to do is say, look at these financial statements, they're materially mistaken. And the burden of proof now it shifts to the accountant. The accountant has to prove that either the third party did not rely on the financial statement or that they did a proper audit in accordance with GAS. The auditor liability under this act often centers on audited financial statement issued to the public in annual report. Rule 10b-5 are often called, sorry, I'm jumping to the 34 Act. So still the 33 Act, the auditor, now the burden of proof shift from the person suing, the plaintiff, to the defendant, who is now the auditor. So the auditor has to show that they did nothing wrong, that either the course did not rely on the financial statement or that they did a proper audit. Now, the 33 Act was enacted in 1933, and it applies for first-time registrant. Now, what happened subsequently? Well, in 1934, Congress realized, hey, we need to do something more, and they came up with the Securities and Exchange Act of 1934. And the Securities and Exchange Act of 1934 applies to all public companies. All public companies have to file an annual report with the SEC every single year. Included in the annual report are audited financial statements. All public companies also have to file a quarterly report. And included in the quarterly report are financial statements also that need not be audited. The 33 and the 34 Act are the Full Employment Act for accountants. Just look at what happened now. Every public company, think of how many public companies out there, they all have to have an annual audit every year. So think what this does to the audit profession. Now, let's go to the 34 Act, Rule 10b-5. Rule 10b-5 is referred to as the anti-fraud provision. It's under Section 10 and it's Rule 10b-5. Its sister violators states that auditor must have the knowledge and intent to deceive in order to be liable for violation of Rule 10b-5. 10b-5 is where the auditor can be held liable for fraud. And for the auditor to be held liable for fraud, they must have knowledge and intent to deceive. Now, as I said before, knowledge is not that difficult to prove, but intent is very difficult to prove. Then go back about 10 or 15 years ago, the SEC came out with the PCAOB, Public Company Accounting Oversight Board, and they can sanction and suspend practitioner if they are in violation of the SEC rules. SEC has temporarily suspended a number of individual CPAs from auditing SEC client. So if you're auditing SEC client, you want to make sure that you're doing the proper thing, because you don't want to be suspended, you don't want to be disbarred, although every year a few accountants are suspended or disbarred. The third act we're going to talk about here is the Foreign Corruption Practice Act of 1977. And there are two parts to the Foreign Corruption Practice Act of 1977. One part deals with every public company must maintain audit proper books and records and a proper system of internal control. Well, who maintain the books and records? The accountants. Who maintain the system of internal control? The accountants. So this act further creates jobs for accountants. The second part of the act states that it's illegal to bribe foreign officials. Make it illegal to bribe foreign officials. And in 2002, the SEC came out with the Sarbanes-Oxley Act because companies were going out of business in the late 90s, and the public wants to know what's going on. So the SEC stepped in and they came out with the Sarbanes-Oxley Act, which created also the PCAOB. But additional to the PCAOB, the Sarbanes-Oxley Act of 2002 required that CEO and CFO must certify the financial statement filed with the SEC. Management must also report on the effectiveness of internal control over financial reporting. An auditor must provide an opinion on internal control over financial reporting. So now for public companies, the auditors provide an opinion on the financial statement as well as an opinion on the system of internal control. What constitutes criminal liability for accountants? So criminal liability means that you're involved in fraud. So Legal 5.3 gives you a diagram. Breach of contract is not criminal. Negligence is not criminal. Gross negligence is not criminal. Constructive fraud can be held to be criminal, right? And fraud itself, knowledge and intent is considered criminal liability. The Sarbanes-Oxley Act further makes it a felony to destroy or create documents to impede or obstruct federal investigation. This comes directly out of the Enron case. In the late 90s, when Enron was audited by a company called Arthur Andersen, which was one of the biggest accounting firms, didn't have to run any longer. And Arthur Andersen gave a clean opinion. When the SEC started investigating and Enron got into financial trouble, Arthur Andersen reportedly started shredding the documents. So this was placed in the act to make it illegal to do that. Auditor defense under the 1933 or 34 Act, lack of duties to perform, no negligence performance, contributory negligence. This defense is only good against the client. It's not good against the third party. It's not good against the 33 Act. It's not good against the 34 Act. And absence of causal connection is good against the parties. But all this going on with legal liability, the profession, the auditing profession, and the accounting profession have to be aware in the back of their mind, whenever they're doing an audit job, that there could be a lawsuit. So they have to seek ways of defending themselves. And one of the best ways of defending yourself, one of the best way of defending yourself and reducing the threat of litigation is to do a proper job. If your audit comply with the standards, then you will not be liable. So the profession responds to legal liability. How do they seek protection from numerous litigation? One is to improve auditing to better meet users' needs. If auditors do a better job, there'll be less chance of they be liable. And to educate users about the limits of auditing. Educate users that whenever there's a business failure, doesn't necessarily mean that there is an audit failure. How are we protecting ourselves? How are accountants and the accountants are protecting themselves? One, by standards and rule setting. Two, by opposing lawsuits vigorously. Three, by educating users. Four, by sanctioning members for improper conduct and performances. We need to clean up our act. We are a very credible profession. And the reason why we have the credibility is because the public trusts us. We don't want to lose that trust. So we need to police ourselves to make sure that accountants are not doing improper stuff. And we want to lobby for changes in the laws. Right now, anybody could sue you as long as an attorney takes the lawsuit. You have to spend the money to defend yourself. We need to change that. Protecting individual CPAs from legal liabilities, deal with honest client, hire qualified professional, follow the professional standards, and maintain independence. And if we do that, we will limit our exposure to liability. Protecting individual CPA from legal liability, deal only with client possessing integrity. Maintain independence, understand the client business, perform quality audit, not just the minimum standard, perform good quality audit. Document the work you perform properly. In chapter 7, we're going to talk about documentation and exercise professional skepticism. Furthermore, we carry adequate insurance, liability insurance, and we seek legal counsel. We choose a form of organization with limited liability. Today, most accounting firms are operating under LLC or as LLPs. And this concludes Chapter 5 lecture. Let me stop sharing my screen. Any questions, guys? Sorry, guys. Were you able to hear the video?
No, we wasn't able to hear it.
Because I'm on mute. Sorry,
We wasn't able to hear
I
it.
didn't hear you. Was you able to hear it? Oh, my apologies. It's on Blackboard also, so you could go into chapter 5. You'll see it there, and you could play it again. My apologies. Because it was coming clear here, I thought you were hearing it. Were you able to hear me clearly?
Yes, we can hear you clearly.
Yeah.
Yes.
It's not the video. My apologies. I stopped sharing my screen, so I didn't have that interaction. Anyway, any questions? Yes, spring break is coming up. So have a wonderful spring break. When we come back after spring break, we'll talk about chapter 6 and chapter 7. And then after chapter 7 will be your second exam. Okay? Enjoy your spring break and have a wonderful day.